Court does call the case of the people of the state of Michigan versus Andrew Cooper.
Sophia Curry is going to be there.
Morning, Your Honor. With our respect, on behalf, sorry, not with, but on behalf of Mr. Cooper on both cases.
All right, Mr. Cooper, can you state your name, please?
Stephen Rizzo Krupar.
All right.
And we are good to go forward as we discussed next week. We're waiving exam, Your Honor.
On both of these cases?
Yes.
All right. Mr. Cooper, you're waiving your right to have a preliminary examination?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Yes, Your Honor.
All right. Preliminary examination having been waived, defendant is bound over to circuit court on all 8 counts as contained in the case ending in 5689 and on the single count in the other matter. Mr. Downs.
Now, sharing copies of information by further reading and studying.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to all charges. Pre-trial in these matters will be set for
April 29th at 1:30 before Judge Simpson.
April 29, 2025, 1:30 before Judge Conkey. Bond will continue in these matters. Thank you.
Thank you.
Court does call the case of the people versus Jerry Ashley.
Andrew Childers, declared on behalf of people now.
And good morning, Your Honor. Just to tell you, the Defendants of Jerry, I really on behalf of Mr. Jerry Ashley, who is on to Judge.
Oh, there he is. Mr. Ashley, can you state your name, please?
Yes, sir. Jerry Ashley.
Thank you. What are we doing?
Your Honor, today is the date and time set for preliminary examination for probable cause conference. Mr. Ashley would like to waive his right to a preliminary exam and ask that this matter be set for pre-trial in circuit court. There has been an offer extended by the people.
And is a waiver part with that offer? Or
I didn't hear you, Judge. I'm sorry.
did somebody want to put the offer on the record prior to the waiver?
Your Honor, I did email Mr. Ashley is serving an MDOC sentence, effectively the offer of the plea on his file. We agree to the current MDOC sentence. I think something around 24 months to 15 years. I believe he's doing 33 months to 10 years on his current sentence.
Got it. All right. All right. Mr. Ashley, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive the right?
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Ms. Akinrelli.
Yes, Your Honor, he does waive formal reading of the complaint, stand mute, and of course, enter a not guilty plea.
Defendant every waive formal reading, standing mute, court will enter a not guilty plea. Pre-trial will be set for
May 7th at 1:30 before Judge Conlon.
May 7th, 2025, 1:30, Judge Conlon. Bond will continue.
Thank you.
He needs to. Court does call the case, people versus Krista Riopel.
Echelon of the people. As the public defender, tonight, carry out on behalf of Mr. Riopel. Ms. Riopel, could you state your name for the record?
Krista Riopel.
And Your Honor, we're asking for an adjournment in this matter. We have received a date to meet with Ms. Riopel, so I'm very hopeful that
You have what, say again?
we've received a date. Our social work department has finally been granted permission to meet with Ms. Riopel, so hopefully we'll be able to get that information.
All right. Probable cause conference without objection, May 1st, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you. Court calls case of the people versus Stephen Bauer. Oh, he's coming out. Is that all my?
That is all your comments, yes, sir.
Good morning, Your Honor. Hello, we're gonna have-
Well. How are you?
I'm well, how are you?
I'm doing great. Welcome back. I was gonna say, look what the cat drug in, but that would be inappropriate. Mr. Burgess.
Good morning, Your Honor. May it please the Son of my court. David Burgess on behalf of Stephen Bauer.
All right. Your name, sir?
Stephen Bauer, sir.
All right. What are we doing on this case?
Your Honor, I've advised my client of his right to examine this matter. He's choosing to voluntarily waive that right and have his case filed over to circuit court for further proceedings.
Is that correct, sir?
Yes, Your Honor.
You understand that? Oh,
I'm sorry to interrupt, but
No.
prior to a waiver, I don't believe that discovery has been turned over in this case yet. We don't have an appearance from Mr. Burgess, so before I was comfortable waiving.
You- you don't?
Judge, I filed an appearance at the arraignment on the warrant.
We did not, our office did not receive an appearance or discovery request from Mr. Burgess.
Oh,
If that's not the case, Judge, I'll fix it today.
pardon?
If that is not the case, I'll fix it today, but I did appear at the arraignment on the warrant.
Okay, but you guys have the discovery or no? I guess the question is whether or not this is going to be a knowing waiver, given if the discovery hasn't been turned over.
Your Honor, I have
But-
discovery in the case and I've discussed it with my client as well as Mr. Kennedy from the prosecutor's office. And he's aware I was waiving today, made him aware already.
I have his appearance. Pardon?
As long as he has discovery, then I would be comfortable with waiver.
Yeah, I have his appearance entered on March 20th or 26th. Okay. All right. And so you're comfortable waiving preliminary examination given that discussion?
Yes, sir.
All right. And you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on all 5 counts. Mr. Burgess.
Your Honor, we'd waive any reading of the information, stand mute as the charges contained within.
All right. Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all counts. Pretrial will be set for
April 24th at 1:30 before Judge Slay.
April 24th, 2025, 1:30 before Judge Slay. Bond will continue.
Thank you. Your Honor, there was one matter. I'm sorry, Judge. Judge,
Yes.
he doesn't have access to his tablet at the jail just for commissary and video visits. I don't know why there's an order not using the internet, which I understand, but I just want him to be able to use his tablet while at the jail to get commissary and video visits with his parents.
He should not have any access to the internet. I believe he would have access to the internet via that tablet.
I don't know. We had some, in another matter, there was some discussion about that. I'm not going to change the bond condition. You can check with the jail. My understanding is there is something regarding the tablets that there is not internet access, but I'm going to leave that to the two of you to check with the jail, understanding the objection and the request of the defendant, and then you can put an order before Judge Slay. But I'm not
Thank you.
changing it at this point. All right? Thank
Yes,
you.
sir.
Court does call the case of the People versus Alan Payne.
Ready, Your Honor.
Speaking of pain, I mean, no, I'm sorry. I'm sorry. I'm sorry. That just kind of came.
Wondering how you were going to.
Especially like people.
Connor Johnson, on behalf of
All right, you're requesting it. Your name, sir?
LP.
Thank you. And you're requesting an adjournment in this.
I proposed a resolution that Ronnie that needs some more support. So yes, sir.
All right. How much time are you going to need to do that?
Roughly 3 weeks-ish.
All right. Without objection, probable cause will be adjourned May 1st, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of People versus Kurt Burke.
Morning, Your Honor. Christie Stokes on behalf of Mr. Burke, who's coming out right now, standing for the attorney of record, Dan.
Wow.
Kurt William Burke.
All right. And you have no objection to Mr. Eastrom standing in for Mr. Davis?
I'm part of the hearing. Your Honor.
Oh, okay. Do you need, hang on, let's get you some equipment. So you. Can you hear me now?
Yes, sir.
All right. You have no objection to Mr. Eastrom standing in for Mr. Guerin today?
I do not.
All right, very good. All right. You're requesting an adjournment in this case?
For 1 week, he had another case scheduled already for next week, Your Honor, so we said.
Oh, okay. So to get the cases together. All right. Probable cause conference will be adjourned then to the 17th, April 17th, 2025. 9 a.m. Bond will continue. All right, thank you. Court calls case People versus Cyrus Abadi. Is that it for you, Mr. Eastrom?
No, I have one more.
Okay.
You know, once in-house case. It's just a call. I think
Or will her on behalf of people, please grab it.
good morning, Your Honor. With us with on behalf of Cyrus Abadi, section. All right, before our call conference, there's a request for a brief adjournment for discovery and some information.
No objection.
Okay, thank you. That's okay. You took care of it, Ken, huh? Oh, hello, good morning. And they're requesting an adjournment. There's no objection, I presume. Probable cause conference, May 1st, 2025, 9 a.m. Bond will continue. Thank you. Court calls the case of People versus Ashton Dew.
Ashton, on people.
Video. Your Honor, Showdowns on behalf of Mr. Dew. Your Honor, there is a waiver before you, but let me give a little context.
Okay.
We were here, the probate attorney did go back to the circuit court, but the circuit court refused to issue any more orders. Yes, I know, and I know the court's been helpful. So wait, we've done some work on our end. We hope the court will. My client's grandmother is here. She's the.
So he never got it right?
That is correct. But we've done some work here. I know, believe me, I know. My client's grandmother was whom my client resided. She was the whistleblower. And so I'm telling you that for a reason. What the parties have agreed to, and that we hope the court will agree, is that my client's going to waive his right to preliminary examination. We're going to ask the court to amend the bond by our agreement to change it from a $50,000 10% to a $25,000 10% bond, keeping the GPS condition of the bond, GPS type. My clients agreed to go back home and reside with his grandmother, to abide by her household rules, and most of my client's grandmother has, through his insurance, arranged for a referral from his primary care physician to an outpatient mental health treatment program. The waiting list is, the shortest one she can find is 1 to 3 weeks, but my client must voluntarily make that referral or follow through on that referral. So that would be a condition of his bond. And then another condition of his bond would be to sign a release of information to update community corrections that was doing exactly what he's supposed to be doing.
All right. Is that a correct statement on?
It is, Your Honor.
Okay. So am I going to get an order to that effect?
I can make that happen, sir.
Okay, why don't we do that? And then I just won't sign because I lose jurisdiction. So I need that today if we could.
It'll be done by the close of the morning for sure.
All right, very good. Okay. So I'm not gonna do it that way.
If I know Miss Yu, she's watching this on, you, is this on YouTube?
Sure.
Then she's making it happen while we're talking.
Is she? Then I'll just wait. Given how efficient she is, it will be coming to us any moment. We'll wait for the 10-second delay and then it will show up. All right, so he's gonna waive preliminary examination.
Yeah,
All right. Is that correct, Mr. Dew?
that's right.
All right. And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts. Mr. Simon.
Sorry, Your Honor, we have formal reading of the information stand.
Defendant having waived formal reading, standing mute to both counts, court will enter not guilty plea. Pretrial will be set for
April 24th at 1:30 before Judge Slade.
April 24th, 2025, 1:30 before Judge Slide. Bond will continue, bond will continue at this point, and then I'll sign the order.
Thank you, Your Honor.
Is anything coming over rather than send it down? All right. Court calls the case of the people versus Christian Leo.
So the attorney here to the people.
And good morning, Your Honor. For the record, Brian Stacy on behalf of Mr. Leo, P33014.
Good morning, sir. Mr. Leo, can you state your name, please?
Christian John Leo, Your Honor.
Thank you. All right, what are we doing?
Judge, at this time, my client recently was released from the Oakland County Jail because this charge violated his probation. And but at this time, he wishes to avail himself of having a preliminary examination in this matter.
Is all discovery complete?
Yes, Judge, as far as the defense is concerned.
People have their witnesses available April 22nd. Preliminary examination in person will be set April 22nd, 2025, 9 a.m. before Judge Freshour.
Judge, okay, and what location would that be, Judge?
It'll be right here at this location where I am.
Okay, and Judge, I have one housekeeping matter. The Washtenaw County Community Corrections, the bond release in Oakland County, I have the order in my hand. It says the defendant will maintain wearing the GPS tether until further order of the court. So Oakland County is aware that he's wearing your tether, but apparently the Washtenaw County Community Corrections wanted it to be okay that you're all right with Mr. Leo only having the one tether. He's on $100,000, 10% tether with you, and he's been wearing the tether with you for over a month now. But apparently, I've never heard of this before, but the Community Corrections wanted you to be aware of that and that you're okay with that.
But he's wearing the tether at this point pursuant to our order.
Yes, that's accurate, Judge.
All right. And I guess, yes, how do they want it communicated that I'm fine with that? I mean, as long as he has the tether on, I don't.
Well, no, I'm assuming that as long as you know Community Corrections doesn't have an issue, we could ask Mr. Leo. He was the one advised of this. I've never heard such a request. Christian,
go ahead, Mr. Leo.
So I was released from Oakland County with their Oakland County tether. They informed me upon release to get in touch with the Washtenaw Corrections regarding a Washtenaw tether possibly. And then once I reached out to that agent, he said to just make sure it was okay with the courts that I have the one GPS tether from Oakland County. Now, the Washtenaw Community Corrections guidelines where I'm not supposed to be at the victim's house is already implemented into my Oakland County tether. So it's all like 2-for-1 type deal going on, if that makes sense.
Okay, now that makes sense to me. And that's why Community Corrections is asking Because otherwise what they will do, since his tether that he has on currently is an Oakland County tether, if it's not okay with me that he wears that Oakland County tether, then they're gonna put another tether on.
Correct.
On our case.
Yes.
And we do that out of efficiency and because he has two legs. No. So I don't, and the Oakland County order indicates. All right, why don't we do it this way? Somebody prepare an order just indicating that the defendant is that the tether provision for Washtenaw County will come into effect if he's released from the Oakland County tether. So that he only has, the purpose of that is that he only has to wear one tether. But the moment, if for whatever reason, Oakland releases that tether, he has to come to community corrections to have our tether placed on it.
Okay, so if the tether ends in Oakland, then he's to get the tether in Washtenaw.
Yes, sir.
Okay, great.
He's to immediately report to community corrections for placement on our tether.
Right.
And then another thing, Your Honor, the supervision agent had also mentioned that I had to bring up, I guess they have me out of the system now for the drug testing and alcohol monitoring as well. That was part of the tether deal. So I just want to mention that to you. Maybe we have to put an order in to get me back on that list. I just want to comply with my bond. I don't want to have any hiccups there.
So they took you out of the system for the testing portion of it.
Yes, that as well.
All right. I need to look at it. I'll just enter a new order. We'll get you back on the system.
Okay, so starting, want me to give a call to Washtenaw Community Corrections?
We'll be doing that within the next, how long is it gonna take? Oh, it's already in your hand. Probably in the next 30 minutes at most.
All right, I'll give them a call
All right.
later on and I'll.
Call over there and once they receive the order, they'll get you back in line on that.
All right, sounds good. I appreciate your time, Your Honor.
Not a problem. All right. And Mr. Stacy, you'll send over the other order to us, correct?
Yeah, that's accurate, Judge.
All right. Thank you, folks.
Okay, and Judge, where do I send the other to your courtroom then?
Pardon?
I'll send the order to your court reporter or to your courtroom.
Yes, that's fine.
Right. Okay, thank you, Judge.
Thank you.
Thank you, Your Honor. Have a good day.
You do the same, sir. Court calls the case, People versus Devin Gibson.
And then on behalf of the people, Your Honor.
Yes, sir. Please, for Brendan Bird on behalf of Devin Gibson.
Good morning, sir. Your name, sir? Thank you. All right, you're requesting an adjournment.
Make sure we have all discovery. It's found out today that my client's getting arraigned on at 1 o'clock.
And that's correct, Your Honor. There was a warrant from February of this year that I authorized last night for a home invasion first, a DV, and an assault. And that's up on the arraignment docket today at 1.
Are you going to represent him on that? Or do you know? Okay. Then I'll just let it flow through. Otherwise, I was going to go grab the file and do it. But, all right. So if he's arraigned on that today, they're going to set 24. All right. So probable cause conference in this matter will be adjourned to April 24th, 2025, 9 a.m. Bond will continue in this case. All right. And what we'll do, counsel, in case that's how it's going to be done, we'll notify them that we've set this one over so that when he's arraigned, they'll set the PCC for the same day. All right. Thank you. You do the same. Court calls the case of the People versus Cameron Hanlon.
Morning, Your Honor. Good afternoon. Cameron Hanlon.
Thank you. Yes. And I've signed the substitute. All right. We put your other case to the first. Did we put your other case to the first?
We did, yeah.
Okay. Without objection, probable cause conference will be adjourned May 1st, 2025, 9 a.m. Bond will continue. Thank you. Court calls the case People versus Daryl Hicks.
Morning, Your Honor, Sam Bernstein with on behalf of Mr. Hicks.
And that's all. All right, go ahead.
Your Honor, we're asking to proceed to examine and all set on instruction.
People have their witnesses available the 22nd. All right. Preliminary examination in person, April 22nd, 2025. 9 a.m. before Judge Fresho. Bond will continue. Thank you. Court calls case People versus Axel Saldivar. It is.
And your children, they're not, we have people around. Chrissy Stowe, on behalf of Axel Sanchez, so.
Your name, sir? Okay. You're requesting an adjournment.
Your Honor, Mr. Childers and I have spoken, we're asking for, the client to sign a waiver, we're asking to put the case out until later May if possible. There's a lot to do on this case, so, I don't believe if people have any objection. We certainly don't.
But what if I do? What happens?
That would make.
Okay. Do people have any?
22nd.
Second. That'll work. Probable cause conference set May 22nd, 2025. 9 a.m. Bond will continue. All right. Thank you.
Thank you very much.
All right. Court calls case People versus Don Miguel Lee.
Anderson on behalf of People.
Your Honor, Sam Bernstein with on behalf of Mr. Hicks.
This is an old one too.
Yes, sir.
I don't need the old one. All right, go ahead.
Your Honor, we're ready to proceed.
State your name, please.
All
All right.
right. Ready to proceed to examine, Your Honor, with all set on instruction.
All right, on both cases.
Yes, Your Honor.
People have their witnesses available the 22nd.
For best, Your Honor.
So. Preliminary examination in person will be set April 22nd, 2025, 9 a.m. before Judge Washington on both matters.
Thank you, Your Honor.
All right, bond will continue. Thank you.